Hey, welcome from the Decoding IP team. This is Antigone, Peyton, and with me is Kandis, Koustenis. As always, we're here to talk about interesting IP and technology law issues that are making headlines. And as always, we want you to try to understand them in plain English, not try to get through this legalese. That's our job, to break it down for you, to decode it so you can understand how it affects your life and your business. So welcome and thanks for joining us. Today we have a great topic that's gotten a fair amount of press, and it relates to an Asian rock band who made it all the way from a measly little trademark filing at the U.S. Patent and Trademark Office all the way through victory at the Supreme Court.
Yes.
So Kandis, let's talk about the In Re Tam case and why everybody's talking about it. And first, let's talk about In Re. Like the naming of these cases might be strange to other people. So,
right.
Yeah,
well, and then
usually it's two parties. So what's going on here?
Right. Well, because when this case first started, it was not, it wasn't a dispute between two parties. It related only to a trademark application. So there was one party. So you can't say Tam v. Jones. So you say in re, in the matter of, it's Latin for in the matter of. So it's in the matter of Tam, in the matter of his trademark application. And so it made its way up. I think when it was actually, once it got to the Supreme Court, I think they turned it into Lee versus Tam, because Michelle Lee was then the director of the PTO. When the decision came out, it's now under a different name, just because we have the interim director of the PTO. But yeah, in re, in the matter of, because it came out of a single filing at the U.S. Patent and Trademark Office, not a lawsuit.
But what a huge deal it made. So let's talk a little bit about this trademark application. So the band, the Slants, they were trying to get a trademark registration for their name. So they had been using the name for a period of time. They're a band of Asian descent. And in their own words, they filed for this registration because they wanted to take a term that had been used in a derogatory sense to talk about those of Asian descent, and really take it back and own it in a positive way. Really take it and make a positive message out of it, a pro-Asian bent, if you will.
Right.
And so that was their purpose for filing a trademark application.
Yes.
The USPTO said, no trademark for you. And they called it a disparaging term and talked about the negative connotation associated with the mark. So the Slants weren't going to take that. And Kandis, let's talk about what happened after that.
Yeah. Well, they didn't take it, right? So they went up through the various channels. The first stop is to appeal to the TTAB. Did they do that, or did they go to the district court first? When you lose in the trademark office, you have two options. You can file an appeal, and that's still within the Patent and Trademark Office. It's an administrative appeal, or you can file a lawsuit directly in a federal trial court.
They went to the TTAB.
They went to the TTAB,
which is an agency board that reviews things that the PTO does relating to either granting or actually denying an application in this case, or disputes between parties about whether a registration should be taken away or whether a registration should issue. So in this particular case, they went to the TTAB, and the TTAB said, yep, our examiner was right. This is a disparaging mark. We're not going to give you a registration. So then,
still no trademark for you.
So still no trademark for you.
Right.
And then they went to the Court of Appeals for the Federal Circuit. And that is a specialized court that deals with a variety of appeals from the U.S. Patent and Trademark Office, and the Federal Circuit gave them a different decision. You want to talk a little bit about what the Federal Circuit did, Kandis, because I think that's a good start to the discussion about what the Supreme Court was thinking about. They had very similar mindsets.
Yeah. Well, I mean, essentially the Federal Circuit said, look, yes, trademarks are used to sell goods and services, but they also have an expressive content, can have expressive content. And in this case, certainly there was an expressive element to the band's name.
A positive vibe for a term that was a pejorative term historically.
Right. I mean, and, you know, not for nothing, but other trademarks along the lines of the slants had been previously accepted by the trademark office. So
now, this is important.
So one of the underlying themes is just how impossible it was to sort of predict whether or not you would be capable of receiving a registration under the terms of this particular clause, which we haven't mentioned yet, but the particular provision of the Trademark Act that the Trademark Office was relying on and rejecting. So, you know, it was so subjective that it was, you know, impossible to predict. And so, you know, you had many marks that were allowed to register that one could consider disparaging, and then others like the slants who, you know, just depending on who you have, were told, you know, no. So recognizing that there can be an expressive content, the Federal Circuit wrote a very strong opinion stating that the provision of the Trademark Act was unconstitutional because it restricted right to free speech under the First Amendment.
And what that means is the USPTO cannot make a decision to block your mark or say, no, you're not entitled to a registration on your mark, even if it believes that the term or some aspect of a logo or something associated with the mark might be disparaging to some, or some people might find offensive, right? So that's very significant because, as you just mentioned, Kandis, one of the things that happened during this case is a lot of people did some digging.
Yeah.
And they figured out that there were very haphazard decisions at the USPTO, which really didn't help the government in its position that this should stand, and it was doing a good job in policing disparaging marks, because people came up with lots of lists of things that looked pretty disparaging, but had made it through the office and through certain examiners, and others that just didn't seem quite as bad, depending upon your viewpoint, but the office rejected them. So there was no continuity, you know, you really
consistency
between the decisions from one examiner to another. Yeah, so that certainly didn't help the USPTO.
Right, and so the particular clause at issue is a particular section of the Trademark Act that says, no registration shall issue for a mark that is considered disparaging to any persons, institutions, or beliefs. And so here, the Trademark Office said, this is disparaging to persons of Asian descent. And so that's the clause at issue. The Federal Circuit said, no, this provision on its face is basically making decisions as to whether or not to permit or restrict the speech of the trademark based on its viewpoint. In the PTO's subjective opinion, this was disparaging. And then add to that the fact that it is so inconsistently applied. So an argument that ran throughout this case in various of the appeals was an additional constitutional argument that it was void for vagueness. I mean, just on that basis alone, because it's almost impossible to determine whether or not you are within or without the restrictions of the Trademark Act, that alone would make it unconstitutional. That didn't make it to the Supreme Court.
And so what that means, just to put a little more color on the void for vagueness idea, it's the concept that people, when you create laws, people need to be able to understand them and understand how they're going to be applied. There should be some way for people to figure out whether they're meeting the law,
complying
or they're not meeting the law, right? So the void for vagueness concern is the fact that when you just have this language in the trademark law that talks about disparaging but doesn't have any factors to consider or any rules or really any guidelines for understanding what disparaging is, you know, it's like beauty, it's in the eye of the beholder, right? And so that was consistent with the fact that certain things were making it through the office that seemed pretty disparaging, and there were others, like, you know, one of my favorites is Democrats shouldn't breed, right? That was one that was too offensive to make it through the office, and I think that's kind of funny, right? Other people were clearly more offended, and the examiner thought that it was disparaging. So.
Right. Well, it's precisely the fact that there can be expressive content in a trademark that makes it so difficult and so subjective, because to your point, I mean, what's disparaging to you may be empowering to me, right? And that was the slants argument. By taking this term back and using it ourselves, we are empowering and putting out a positive message. That's their opinion. Obviously, someone at the PTO had a different opinion, but that's incredibly subjective. So it's going to be difficult to know who's going to agree with your opinion, who's not.
Well, yet another famous example, and this is related to a case that's currently in the courts and a lot of people know about, the name of our Washington football team, the Redskins. People have very strongly held views about the name, and there are some people who have,
including Native Americans disagree.
Including Native Americans disagree about whether it's disparaging or not. Right. So, that's another example of a name that is very well known and carries a wide variety of feelings associated with the name. But that case has really been affected by what happened here. Yeah. So maybe let's talk about the Redskins. Yeah. Right. So a little background. So, for decades and decades and decades, there has been discussion about the Redskins names. And, every 10, 15 years or so, there will be some kind of legal attack against the Redskins name. But it's been around since the 1930s, and the registrations started in the 1960s.
Yeah.
Right. So these have been long-term registrations that have been attacked. Now, the latest attack was actually successful. So the 4 marks that the Redskins had were struck at the USPTO, to the point you already made about the various legal avenues that you can follow. The Redskins then went to the district court here in Northern Virginia, the Rocket Docket, and they tried to get that judge to come to a different outcome. That judge did not, and then it went up to the 4th Circuit, so a different appellate court than the Slants case. And the 4th Circuit hadn't decided the case. That case was on hold while the Slants decision was being considered by the Supreme Court. And actually, the Redskins tried to get their foot in the door at the Supreme Court, even though they hadn't gotten an opinion from the appellate court that was deciding their case. They asked the Supreme Court if they would do something incredibly unusual and take their case as a companion case to the Slants case.
And basically, they asked the Supreme Court essentially to bypass the 4th Circuit, basically saying, we know this is going to come up as well. Here are the 2 cases, the Redskins and the Slants at the same time. It makes sense because they're both, coming from different procedural perspectives. Yeah. Right. And the Redskins actually was a dispute. It was not coming from an application filed at the PTO. This was a longstanding dispute where a group of Native Americans moved to cancel existing registrations. In this second go around, the PTO said yes, and the district court said, we agree, these should be canceled, waiting in the 4th Circuit. When the 4th Circuit heard that the TAM case had been accepted, the cert petition had been accepted, they put the case on hold. The Supreme Court obviously said, no, we're not going to bypass the 4th Circuit. We're not going to hear them at the same time. So then the Redskins also filed an amicus brief, a friend of the court brief.
Supporting the TAMs, obviously.
Kind of weighing in. Yeah. Yes.
So anyway, Kandis, let's talk a little bit about this concept of free speech versus government activity and government forums, because this is a concept we've actually talked about a couple of times in our latest podcast and live stream. It came up most recently during the discussion about Donald Trump's personal Twitter handle, where we talked about public forums versus private forums. Let's walk through at a very high level the kinds of issues the Supreme Court was considering when they were thinking about what the government could do with respect to this kind of activity, since it did manage the registration process.
Right. So the number one argument, sort of the threshold argument that had to be decided, was the government's argument that the First Amendment doesn't apply here because it is government speech. This isn't private speech. It's our speech, and we can say whatever we want. And the most recent example of that was a case coming out of Texas involving license plates, where Texas was, accepting or rejecting particular license plates based on their expressive content and whether or not it was offensive, scandalous, what have you. In that case, the courts found that it was government speech, but one can see that a lot.
Meaning the government could restrict what was registered and what wasn't.
That was government speech. So here the government tried to argue, well, similarly, trademark registrations, because they're granted by the government, are government speech. And so that was the first big issue, and the court unanimously said, no, this is not government speech. This is private speech. And there are, a lot of very detailed arguments as to why that.
One of my favorite ones, though, Kandis, is basically the concept that if this is government speech, the government is babbling in a way that's completely incoherent, right? And the court really seemed to not only not buy that argument, but they said, come on. It was one of those, come on,
called it
are you kidding me?
A cacophony, so if this is speech, one, you're being incredibly inconsistent. And you're babbling, so I'm not sure how that can be speech.
Thanks for the argument, but that was silly. Move on.
Yeah, and then I think another thing that had great weight for the court was the fact that if this is true, let's not forget, we have another registration system in the United States, and that's for copyrights. So really, you're going to start saying that every artistic work that's registered within the Copyright Office is now no longer the speech of that particular author or artist, but it's the government speech. And they said, no, we can't do that. That's a really bad slippery slope, and we're not going to go there.
Yeah, I mean, that's a nice example of just talking about the bigger impact of a decision the court might make in order to dispose of one case in the way that they want, or in the way that the government is asking them to, and the ripple effects that it would have on other systems.
And one thing that struck me in reading the opinion is I think that in writing the opinions, there were a couple, each and every justice was very mindful of the fact that this could have wide-ranging effects on other types of cases, because it's almost, nothing's bulletproof, but I mean, analytically, they have set this case up in a way that it's going to be difficult to somehow find a loophole for later cases, and say that these comments on free speech don't apply in our situation, and here's why. Because they walked through many arguments and dispelled each of them, and made very strong comments in favor of the First Amendment.
I guess they don't want the Redskins case.
They don't want the Redskins case.
They think they've already decided it.
Yeah, and then there's another case bubbling up in the Federal Circuit as well. And they had to have known. Of course, they know that. So
yeah, so let's talk about that new case that's coming up, because we've been talking about the disparagement block.
Right.
And the fact that the Supreme Court dealt with that. And that really was the only issue in front of the Supreme Court. However, there's two other...
the only issue with the Redskins, too.
Right. But there's this concept of immoral marks which cannot be registered under the same section of the trademark law, the Lanham Act, and also scandalous. Yeah, right. So those kind of feel like disparaging, but they're different words, right?
Well, and it's the exact same provision.
Right.
The exact same provision of the Act says no registration for you if we find it disparaging, no registration for you if we find it scandalous or immoral. And so then the question becomes, what effect, if any, does this opinion have on that portion of the very same clause? And folks say that's up for grabs. I mean, we'll see. There's a case. It's called in the matter of Brunetti, that's in the Federal Circuit right now. They've had oral argument, but no opinion has been coming down. Not surprisingly, they were probably waiting for this decision. And in that case, the application was for a trademark that incled the F word, or something that sounded a lot like the F word. I'm not going to say it, right? It sounded a lot like the F word. And so this is the exact same situation as the slants, but not under the disparaging component of the clause, but the scandalous and immoral component. So the question becomes, what's going to happen now with that case?
So I really have a hard time figuring out how the immoral and scandalous objections to trademark registrations can really survive, because same, even though the Supreme Court didn't specifically deal with those provisions, the Federal Circuit decision by the full Federal Circuit in the In Re Tam case said, look, we're having a hard time finding figuring out how scandalous and immoral survive, given the way that we've analyzed the disparaging clause issues. Yeah. And the Supreme Court agreed with their analysis of the disparaging clause issues. So in other words, even though those particular objections by the U.S. Patent and Trademark Office were not the basis for the Supreme Court decision, and so it's technically not binding, smart people would probably put their money on the fact that those are going down too. Yeah. It's just a matter of time.
Right. Well, yes. I mean, I think analytically speaking, given everything that's been said in this case, it would be very, very difficult to say that it doesn't equally apply to scandalous and immoral. But what's more is, in that case in the Federal Circuit, before this case came down, the Patent and Trademark Office had actually written a letter brief to the Federal Circuit saying, however the Supreme Court rules on the Tam decision, that will equally apply to scandalous and immoral.
There you go.
But what I find strange is, but then there's also been commentary to the effect that the PTO says they're reserving their right to go up to the Supreme Court on the issue in this case. I mean, I think given the analysis here,
that's called hedging.
Yeah, given the analysis and given the fact that you've written a letter brief to the Federal Circuit saying, hey, whatever happens in Tam is going to rule in what happens here. I don't know. I think that's kind of difficult. So I think that issue is pretty in the bag in the sense that the entire clause, whether it's scandalous, immoral, disparaging, it's just gone. And we're going to let trademarks enter into the marketplace of ideas and, let the better speech win.
So I think this is really interesting, particularly in light of our current political climate and the discussions around of a wide variety of issues that are happening in the United States politically as well as the world, right? Yeah. So when we think about the ways that people talk about things, sometimes they create monikers or taglines. Some of our late night show hosts are well known for creating characters that are sort of made up versions of politicians or other people. And there are trademarks that are circling around these kinds of discussions. So to your point about the marketplace of ideas, registration is not required for trademarks. We should talk a little more about what that means. But registration brings some additional benefits surrounding protection of that speech that's different than the kinds of protections we talk about with the First Amendment. So let's differentiate between registration. And there was a big deal about this made in the In Re Tam case. So trademark rights, for any of you who ever wonder if you have trademark protection, trademark rights can actually attach when you're using a particular item that is protectable under trademark law in what we call in commerce, right? So the question is, what does in commerce mean? Well, there are a wide variety of ways we can describe it, but generally it's, to the public.
Are you offering for sale or services to the public?
Exactly. Products or services. Are you using a particular product name on your website or in your print materials when you're describing what it is, this widget that you're offering? Do you have an unusual company name that other competitors don't have? And that can be protectable by trademark. Logos, colors sometimes, like the Tiffany blue, the Harley sounds like the NBC chimes or the Harley Davidson sort of throaty sound of an engine. These are famous sound marks, right? So there are a wide variety of things that can be covered by trademark law, but what they all have in common is they identify the source of particular goods and services. And you may not know what that source is. In other words, you may not know the company name, but you identify a particular product and understand the quality and the reputation and all of that stuff. That's what a trademark is designed to do. So you get that when you actually start using publicly a particular mark in association with your business or your product or your services, as long, of course, as it's, it passes the requirements for trademark protection. Right. And what we've been talking about is the fact that for a long time, you did not get trademark protection from a registration point of view if you had a disparaging or scandalous or immoral mark as decided by the USPTO. So, right, anyway, so that was one limitation.
Yeah, and that is an interesting issue from the trademark lawyer point of view, but I mean, I think from the practical point of view too, because particularly this came up in the Redskins case. So when all of this was happening with the Redskins and, the registrations were canceled, people were like, oh my God, they're gonna have to stop using their name. This is terrible for them, poor Dan Snyder.
And we went, oh.
Yeah, right. We're like, no. This means no registration, which gives additional benefits, but it doesn't grant the right to use. The use may continue. There was some argument and some commentary in the Federal Circuit opinion in the Redskins case to say, well, wait a minute, we think if there's no registration, then one can't enforce the marks against another. So in other words, okay, yeah, sure, maybe the Redskins continue to use, but they can't sue a third party who decides to start their own football team named the Redskins. And so, that caused a little concern because that would be really bad, right? I mean, then that would mean, yes, one has to have a registration.
But there's common law claims. That
but this was discussed and this was argued. And so it was kind of like it wasn't a footnote, but, kind of a sidebar type of argument that kind of had people kind of perking up because it was like, oh, well, wait a minute, that really can't be. And under the law itself, there is a section of the Lanham Act that allows one to enforce their common law trademarks. In other words, you don't need a registration in order to sue someone. And that's pretty clear, but still the fact that the Federal Circuit had kind of mentioned this made trademark lawyers a little skittish. One thing that the court did here in TAM is they put that argument to rest and said, no, you know what, even without, yes, there are all these benefits to registration and it makes sense and it's a good thing to do, but if you are simply relying on your use in commerce or common law rights, you can still enforce that trademark. So
that's good because in almost every trademark case we deal with, we have common law claims as well as registration-based claims as well. So yeah, that would really throw a wrench in the works if that changed.
So that clarified things so that, yes, as trademark lawyers, we're going to 9 times out of 10 recommend that you get a registration if you can, but rest easy, you are still protected with your common law rights.
So this was a really interesting topic. We'll have to see what the Fourth Circuit does with the Redskins case, and we'll certainly
and the Federal Circuit with Brunetti,
right?
The F word case.
Right. So things will move along after this Supreme Court case, but this has been a monumental shift in the world of trademarks. And boy, I just can't wait to see. Yeah, I just can't wait to see all those new trademark filings with bad words and funny comments about certain people of different political persuasions who should breed and not breed. That's free speech at its finest.
We'll see. I wonder if there will be an uptick.
Of course. Why not?
I don't know.
Just because you can.
But yeah, it's an interesting decision, a very important decision. I mean, so many commentators, even those not in the IP world, the consensus seems to be, this was such a strong statement in favor of free speech and the First Amendment from, our mixed bag of a Supreme Court right now, and only 8 justices because Gorsuch did not weigh in here. you know, it's a really strong statement. And if you're in favor of free speech, it's a good day.
1 for free speech,
Yes.
0 for USPTO.
Yep.
Okay. Well, thanks for joining us. And if you have any questions about trademarks or copyrights or patents or any of the stuff that we deal with on these shows, please reach out to us. You can also follow us on Decoding IP blog. We're blogging about these issues. We're also sharing podcasts. So you can find us in the Apple iTunes store. You can find us on Google Play. And don't forget to follow our Twitter handle, Decoding IP. Thanks for joining us. Look forward to chatting with you soon. Bye.